Okay, this is about student records and everything that we as educators need to know about how to deal with student records. Okay, so the definition of student records. So the primary purpose is to maintain educational records, should be to aid personnel in developing the best educational program for each student. An effective student record contains information for counseling, program development, individualized instruction, grade placement, college admissions, and a variety of other purposes. A student record includes directory information, family background information, health records, progress reports, achievement test results, psychological data, disciplinary records, and other confidential material. And this is the area that is kind of gray, and a lot of cases have been filed under FERPA to determine what is exactly included in an educational record. So FERPA, that is Family Educational Rights and Privacy Act, and this protects the confidentiality of student records. It may also be known as the Buckley Amendment, and it was enacted by Congress in 1974. It was designed to ensure certain types of personally identifiable information regarding students won't be released without parental consent. So a student who is 18 or in a post-secondary institute, they may access their own student records, but only once they reach 18. FERPA applies to school districts and schools that receive federal funds. So any school that receives federal funds is falls under FERPA. And schools should develop policies and procedures that include the types and locations of educational records, and the persons who are responsible for maintaining the confidentiality of the records, as well as copies of these policies and procedures should be made available to parents and/or students upon request. So, what is included and what is not included in these educational records? What is included is the records, files on the students, documents that pertain to the students, and other materials that contain information directly related to a student or maintained by an educational agency or institution or person acting for the agency of institution. What is not included are instructional records, supervisory records, records maintained by law enforcement units for law enforcement purposes, and records on 18-year-old students attending a post-secondary institution that are maintained by a physician, psychiatrist, psychologist, or other recognized professional involved in the treatment of a student. Schools must have an annual notification, and these are the things that must be included every year in this notification. The right to inspect and review educational records, the right to seek amendment of records believed to be inaccurate, misleading, or in violation of the Students' Privacy Act, the consent to disclose personally identifiable information contained in the student's records except where Act authorizes disclosure without consent, the right to file with the department a complaint under 99.63 and 99.64 concerning alleged failures by the educational agency or institution to comply with requirements of the Act. The notice must also include procedures for these rights and specifications of criteria, what constitutes a school official and a legitimate educational interest. So there must be procedures for exercising the right to inspect and review educational records, as well as procedures for requesting amendment of those records. Must include an educational agency or institution must notify parents or any disabled student who is eligible of these rights. And an educational agency or institution of elementary and secondary education must notify parents who have a home language or primary language other than English in their native language. In addition, students and parents must be informed about the procedures to access their educational records. Okay, the rights of parents for their child's record. The parents do have the right to inspect their child's record. School officials should be appointed to answer questions and help help the parents understand any information that they need help with. The parents may challenge the accuracy of information, and if they do, the school should schedule a conference within a reasonable period of time, usually 10 days, to discuss information that may be deemed inaccurate or inappropriate or misleading. If agreement is reached, then the appropriate deletion or correction are executed and recorded in the file and communicated to the parents in written form. If not, the parents may request a hearing where they'll go before a board and they will determine how to handle it. Non-custodial parents, they have the same due process rights to student records as custodial parents. The rights of school personnel. Any teacher, counselor, or administrator, they must have a legitimate educational interest to view records. If they wish to view the records, they must have a written form and sign it and keep it in the file. This should include the files that they viewed as well as the date. Each person viewing the file must sign the form, so any teacher, counselor, and administrator that was present must sign the form, and it must be kept in the file. If this viewing is challenged, the school must be able to demonstrate legitimate interest. FERPA and discipline. In 1994, FERPA amended their rules to include that institutions are not prevented from including records related to disciplinary actions taken against students who cause significant risk or harm to themselves or others. They may disclose this information to school officials who have been determined to have a legitimate educational interest, and they may also disclose this information dealing with disciplinary actions to other school officials in other school districts that have a legitimate educational interest in the behavior of the student. Enforcement of state or federal statutes. Federal and state officials may inspect files without parental consent in order to enforce state laws or to audit or evaluate federal educational programs. Personally identifiable information may not be associated with any student unless Congress by law authorizes federal officers to obtain this data. Information may be released without consent when applying for student financial aid. Authorized representatives who may access records include the Comptroller General of the U.S., Secretary of State, Administrative Head of an Educational Agency, and the state and educational authorities. One of the landmark U.S. Supreme Court rulings dealing with FERPA was on February 19, 2002, when the U.S. Supreme Court ruled in Owasso ISD v. Falvo that peers grading papers does not violate FERPA. Student papers are not maintained within the meaning of FERPA when students correct their peers' paper or call-out grades. Maintain suggests that FERPA should not stop teachers from using current techniques. If homework or classwork were considered to be part of educational records, there would be a substantial burden placed on teachers, including this would require parental consent for even showing a student their own test grade if they are in elementary school. Ray versus the District Board of Trustees of Santa Fe College. The question in this case is a student protected under FERPA when he or she files a complaint against a teacher in public schools and colleges? In 2012, Ray, who was a mathematics instructor at Santa Fe College, was not rehired based on an email sent from a student to the school complaining about his teaching habits. Ray was hired on a semester-to-semester basis and was ultimately not rehired because of this email. When he asked for a copy of the email, he was sent a redacted copy, and the chair repeatedly refused his request to disclose the author's name based on the grounds of FERPA and the student's identity being protected. The email complains about Ray's classroom behavior, such as humiliating remarks and unorthodox methodologies. But Ray alleged he was effectively prevented from defending himself by demonstration that the student was not in position to comment fairly on Ray's teaching. He also asserted that neither the Florida statutes nor FERPA protects disclosure of the name of a student who writes an email, and he alleged further that as a result of the chair's unlawful refusal to give Ray the complete email, he suffered damages by ultimately losing his job. The court ultimately decided to side with Ray, and this is not under FERPA. They are not authorized to keep their identity hidden just for writing an email. That is not part of their student record. Bryner versus Canyon School District. Bryner's son was involved in an altercation in October 2012 at Butler Middle School, and when Bryner asked to view the security footage, he was denied access under the laws of FERPA. The Utah District Court viewed the footage and ruled that it was an educational record because it contained personally identifiable information of other students in the video and was subject to FERPA. The court said students in the video were clearly identifiable either by face, body shape, clothing, or otherwise, and they would however allow Bryner to pay $120 for a redacted version and gave a 10-day period for him to request the footage. Bryner argued that teachers, librarians, and custodians had viewed the footage and therefore he should be allowed to view it. However, the court decided it fell under FERPA, and Bryner appealed the decision, claiming it was not an educational record because it was not academic in nature. The Court of Appeals upheld the trial court decision, however, arguing the video falls under FERPA because it contains information directly related to students, and this was a historic case because this had no academic background, but it was still maintained under FERPA because of the information included in the video that related to other students. And the School Choice Ohio Incorporated versus Cincinnati Public School District. The question was, can a public school rely on FERPA privacy statute to selectively withhold basic demographic information about students? A nonprofit agency, School Choice Ohio, or SCO, alleged the Springfield City School District used its records policy to deny the release of information to organizations it opposed. SCO filed a public records request in 2014 for student names, addresses, and other contact information. FERPA requires districts to keep students' education records confidential, but it clearly exempts harmless directory information of the type that SCO requested. SCO requested the directory information annually from school districts to conduct outreach programs for families who could be eligible for school choice programs such as scholarships or etc. And this information could help local families decide which school to send their children to. The district has several schools in the focus list, which has high achievement and high graduation rates, and one school on the priority list which has low achievement and low graduation rates. Administration thought the outreach could be misleading and did not give them their consent. The district had their current students' privacy policy since 2013, which included sending a consent form to parents to release information. The superintendent could then use discretion to decide whether the information could be released to each requesting organization. The court ruled that the information requested by SCO fell within the boundaries of the consent form and the release would not violate FERPA. Once the district has parental consent for a disclosure, they must release the information if it is requested.